Attorney, what's the funniest way to lose a case when victory is within your grasp? Story 1. Client's social media post ruins wrongful death lawsuit. My wife's lawyer bans all clients from using social media after he lost a big case. Wrongful death lawsuit where a man's wife was killed. Easy money. They were about to settle until the other side found his pictures online from a club, a week after his wife died, getting a provocative dance wearing a shirt that said, "I love older women." Apparently, they didn't think he had much pain and suffering anymore. Story 2. Client's testimony opens door to prior DUI conviction. AM, criminal defense lawyer. Client arrested on driving under the influence, DUI. Client lived in small town. He and his wife would drive to the one bar in town, drink, then walk to their houseboat after a night at the bar, 1/4 mile away. He and wife know everyone in the bar. Another patron they know gets blasted. Bar owner says she can't stay. Client and wife walk her to his car to stay there until ride comes. Client gets her in back seat of the SUV. Client is drunk, drops keys on the way to front seat, opens now unlocked front door, turns on car lights to see. He walked around the front from rear passenger. Cops are waiting to see if people leave bar drunk. Sees lights, says he saw driving, immediately rolled up arrests client. Client has prior DUI from 12-ish years before. Judge agreed that it wouldn't come in, jury wouldn't hear it, unless he, quote, opened the door. Can't win the case unless dude testifies. I prep him, continue to prep him, keep prepping him, but tell him, under no circumstances can he say he would never drive drunk, never do anything like that. Basically, anything about the past equals no. Direct is going well, gave him a beautiful, easy last question where he could explain the night, explain why he was upset he got arrested, because he wasn't driving and was doing everything right. I would never do something like that. Door open, judge lets district attorney DA in rebuttal bring in old Dewey. Jury took about 25 minutes to convict. And that's about one of 100 stories. Life is never dull in the criminal defense world. Story 3. Client's website confession derails trademark settlement. I was defending a client who was accused of trademark infringement. Thought he knew better than the intellectual property, IP attorney assigned to his case, me, and so went on his company's website to defend himself by basically confessing to what he did and claiming it wasn't against the law, and the trademark owner was a sensitive person who needed to learn a lesson. I was one email away from negotiating a settlement that would have allowed the continued use of the complainant's mark, with limited restrictions and a very nominal fee. Little to say, she saw his website, told us to get lost, and dragged it before a judge. My client lost big. His lack of self-control cost him thousands of dollars. Story 4. Client's testimony undermines harm defense. Not an attorney, but I was in the jury for a 3-defendant trial for causing a death. We sat through weeks of testimony, and from the sheer amount of direct evidence the state had, it was extraordinarily obvious very early on that Defendant 1 had committed the crime. Defendant 2, D1's brother, and Defendant 3, D1's girlfriend, were much less obvious, and we were being asked by the state to consider circumstantial evidence that left most of us feeling like we had to make some leaps to draw the conclusion they wanted us to. That is, until Defendant 3 decided to take the stand. Defendant 3's attorney did a very good job of painting her as the victim of abuse. Her attorney had us feeling sorry for this poor, unintelligent woman that had been groomed since she was 16 by a man 20 years her senior. From the attorney's narrative, D3 was basically D1's slave. He controlled what she wore, what she did, and even who she talked to. He even made her get a tattoo saying one's name's property. We saw text about D1 harming D3's puppy. Story 5. Client rejected 0 extra days deal, got 70 years. I had a client that was already serving a 25-year sentence for a series of burglaries. I was representing him for 3 more burglary charges in a different county, just across the county border. The state actually had evidence for 13 burglaries in my county, but picked the 3 best, with ironclad evidence. The prosecutor offered a 20-year concurrent, served at the same time sentence, meaning if my client took the deal, he would serve 0 extra days in prison. I suspect the prosecutor had some sort of metric she had to meet. I met with my client dozens of times explaining that, even if these 3 cases weren't ironclad, he would be risking consecutive sentences if even one of them got a conviction. My client was convinced his original conviction was going to be overturned. He turned down the deal and ran all 3 cases to trial. After the first conviction with a consecutive sentence, the prosecutor withdrew the offer and forced us to trial on the second 2. My client was a young, 23 years old, black male, and is now sentenced to 25 plus 15 plus 15 plus 15 equals 70 years in prison. He will die in prison because he would not listen to the expert appointed to represent him. Story 6. Defendant stripped and confessed during robbery attempt. I prosecuted a similar case. Defendant tried to rob a cash for gold store. He wore a mask and had a gun, but the owner pulled out his own gun and shot the defendant. Dude ran a few blocks, but was found by the cops lying on the sidewalk in his underwear. He decided to strip while running. He said, "I got shot. Robbery." He was recently released from prison for robbery, and the mask elevated it to mandatory life sentence, if convicted. Offered him 20 years before picking a jury, and his attorneys tried their absolute best to convince to take it, but he's clearly not the brightest. Had his DNA on the gun and mask he tossed, and the bullet hole in his shoulder from being shot. 26 years old at time of conviction, and he will die in prison. Though I don't feel at all bad, because we had 2 to 3 other robberies tied to him, and he would have never stopped. Story 7. Husband's rage costs restraining order case. I'm late to the party, but I have seen dozens of parties completely destroy any chance they had of winning a case with one stupid statement or action. Fortunately, most of them have been the opposing parties, and not my clients, but not all. The best was a domestic violence restraining order hearing I witnessed while I was waiting for my client's hearing to be called. A wife had filed a restraining order against her husband, and the wife had retained an attorney while the husband elected to represent himself. The wife testified first, and despite her attorney's best efforts, none of her testimony alleged that her husband had actually committed any real violence or abuse. Basically, she had filed the restraining order because he called her a terrible name while they were having a heated argument. After he had finished asking her questions, the wife's attorney was clearly dejected, and it was obvious to everyone in the courtroom that the restraining order was about to be dismissed. The judge's body language made it clear that she didn't believe there was anything to warrant a restraining order, but she asked the husband if he had any questions for the wife, meaning he was being given the opportunity to cross-examine her. The husband took this to mean could ask any question whatsoever that he wanted, so he immediately asked her if she had had an affair with some other guy. The wife answered no before her attorney was able to object, and this sent the husband into a rage. He screamed that his wife was a liar and lunged toward the witness stand like he was going to attack her. Fortunately, the bailiff tackled him before he could get there, and he was led away in handcuffs. Needless to say, the restraining order was granted, but if the husband had just shut up and not asked a single question, the court would absolutely have ruled in his favor. Story 8. Client posts spin class schedule on Facebook, ruins workers' comp claim. You asking. Score, 5,583. Not an attorney, worked in a firm. Workers' compensation claim. Guy falls down at work and claims he injured many different body parts, shoulder, knees, back. We tell him to stay off social media. No problem, he doesn't use social media. At trial, he tells the judge he used to be a spin class instructor, but since the accident, he cannot teach classes anymore. Welp, turns out he continued to teach these classes after his injury. This was proved by the hours of surveillance the insurance company did, showing him teaching and vigorously riding in spin class. How did the insurance company know he was still an active instructor? The guy posted his full teaching schedule on his Facebook page. His potentially very lucrative claim was quickly changed to a fraud claim against him. Story 9. Client admits to drug use during testimony. I was involved in a pretty messy custody case. The other party was a mess and had kept the child from my client for a few weeks. OP was playing lots of stupid games and kept requesting continuances. I requested a substance test, which the judge ordered. However, the OP didn't show up for it. To clarify, he did show up. He just stood in front of the toilet for literally 2 hours and claimed he couldn't pee. I was representing the plaintiff, so the burden was on me. I called multiple witnesses that testified to the defendant's substance use. So opposing counsel decides to call their client for direct examination and asks, "You don't use heroin and crack, right?" That is, for the non-lawyers, a very stupid question for many reasons, especially considering his client didn't show up for his substance test. However, I fully expected the defendant to just lie and say he was clean. After the question was asked, there was a really long pause, and the defendant said, "Yes, I do both of those." My head almost exploded. I didn't ask any questions on cross-examination because I didn't want to muddy the waters. I won, and the child is doing great. Story 10. Client's outburst ruins directions hearing. Was in court for a directions hearing. The judge was already in a bad mood and asked why we were here for such a seemingly pointless litigation without giving details. He was right. The barrister starts to make our case, and I am taking notes about areas we need to further explore when I hear, "Excuse me, why were you so rude to me?" The client, who had been told to not come, had come to court that day and was evidently incensed by the judge questioning the merit of their case. They berated the judge for about 3 minutes, with me and my co-counsel first stunned, and then trying to shut them up, before he adjourned the hearing. The case did not go very well, to my client's surprise and fury. Big sigh. Story 11. Drunk client falls asleep during video playback in DUI trial. Client charged with DUI. Forced by police to give a urine sample on the side of a very busy interstate highway. Any sympathy the jury may have had for the defendant was lost, however, when he fell asleep during the playing of the video of the traffic stop. He had been out all night partying the night before trial. He was found guilty. Then he lied to the judge about what would be in his system during a substance test, and his sentence was doubled. Story 12. Not a lawyer, NAL, but watched as a girl in her early 20s giggled her way through sentencing on a petty theft charge. Instead of the same 30-day suspended sentence her remorseful-looking co-defendant received, she got 90 days in county jail. She wasn't giggling after that. Story 13. Arsonist client's inappropriate behavior in court affects sentencing. I have 2 stories that come to mind. 1. A colleague of mine was representing an arsonist many years ago that had allegedly set quite a large fire that burned some public land. Due to the dollar cost of the damage, it was a felony. During the state's case in chief, he began touching himself. Recess had to be called. Funnily enough, that helped him in punishment phase, since there was clearly a mental component there. But still, big oof. And I don't know if what had been shown up to that point would have gotten a guilty. Story 14. Client admits punching wife in court. A few others. In another restraining order case, my client had video of his neighbor running up and punching him in the face multiple times for no apparent reason. I submitted the video as evidence and had sent a copy to the neighbor along with the other evidence I was lodging with the court. The neighbor ended up hiring a high-priced attorney prior to the restraining order hearing. I was a new attorney working for peanuts. When the date of the hearing came, opposing counsel was extremely cocky and made an opening argument. The parties had filed cross-restraining orders, accusing my client of threatening and harassing his poor elderly client and making up lies about her. By the time he started arguing that my client should be made to pay his client's attorney fees, the judge cut him off and, with a very confused look on his face, asked, "But what is your position regarding the video evidence?" The attorney was clearly confused and said that he was unaware of any video evidence. It immediately became clear that his client had neglected to share our evidence with her attorney, who was hired after she had been served with it, and had sworn up and down to him that my client was the aggressor. The judge called for a brief recess to allow opposing counsel to view the video, and when court was resumed, the attorney was so deflated it looked as if someone had killed his dog. The attorney mumbled a couple of feeble questions to his client, then basically gave up. It was one of the easiest, most enjoyable wins I've had. Lastly, I once had a client whose wife accused him of hitting her. He swore to me up and down for months that he had never laid a finger on her, and that she was making stuff up to try to gain custody of their kids. Neither party had any evidence, so it was a he-said/she said situation, which was not likely to end with her getting a restraining order or full custody of the kids. When my client testified at court, I was stunned when he immediately admitted on cross-exam that he had punched his wife in the face once. It was clear the other attorney was stunned as well, and before he could ask a follow-up question, my client pulled out a stack of papers and started yelling that he had proof that his wife was a cheater and a liar, which he clearly believed justified him hitting her. The papers were purportedly copies of emails between the wife and a male coworker. I found out soon after that he had spent more than $10,000 on private investigators trying to get proof his wife. Story 15. Expert witness goes off rails with political rants in trial. It wasn't a client, but I had an expert witness go way off the rails during cross-examination during a week-long trial a while back. He forgot all his analysis and data, and just started spewing nonsense from his mouth. Then he became combative with counsel. Then he started making political statements. He was making things up left and right that was nonsensical and was getting cooked by counsel. I could see the delight in opposing counsel, who was having a field day. My client stormed out of the courtroom because he couldn't take it. I was facing the witness stand about 6 feet from our expert in. Story 16. Client reveals hidden photo evidence during cross-examination in slip and fall case. I am a lawyer. I was cross-examining a slip and fall plaintiff on the stand in trial, after like 2 years of litigation. We were going over some pictures he took when he let slip that the picture of the 2 signs was missing. I grilled him on what he meant until the judge chastised me for trying to conduct discovery during trial, which is supposedly not allowed. He had clearly concealed evidence, though. We took a break for the day, and the next day he came back with the photo in question, which showed that he had walked squarely between 2 wet floor signs to go down the Kroger aisle that he immediately slipped and fell in. He did not recover any money in that one, despite the horrific defense venue. The judge who jumped all over me for exploring obvious evidence tampering was later appointed to the federal bench here in Atlanta. Story 17. Client violates bond by using victim's info for fake checks, loses deal. Second was one of mine, again many years ago. I had gotten a guy a pretty great deal on a serious theft charge. Prior to it being entered, he ended up picked up by the sheriff's office for violating conditions of bond. How did he violate? The sheriff alleged that he used the banking information of the sheriff's office to pass fake checks. This meant that in the new charge, the sheriff's office was the victim. Needless to say, the deal vanished. Story 18. Client suffers panic attack on stand, fails to answer key questions. Briefly, he had to testify that doing X thing would not cost him a lot of money. The judge asked him how much money would it cost for him, and he said an amount which was not too much for him, because he was rich, but it was a lot compared to what everybody in the courtroom was making. Other case. The day before the court, I tell him exactly what he is going to answer to certain questions. I specifically tell him to answer X when asked. Time comes, judge asks. He completely loses it. He gets a panic attack. He can't even speak a single word. He just looks at the judge with the 1,000-yard stare. Disaster. Story 19. Client clenches fist in court, contradicting arthritis defense. Client accused of punching another man and knocking a tooth out. He said numerous times on the stand that he had arthritis and was not capable of closing his fist to form the punch, as described by the victim. Partway through his cross-examination, the magistrate stopped him to state on the record that he had watched my client clench his fist numerous times since he made that statement. He was found guilty. Story 20. Client misunderstands threat distinction in police interview. Client in the interview with police officer. I don't care how angry you are. You can't go around threatening to harm a 5-year-old. Client. I didn't threaten to harm her. I threatened her mother. He thought there was some sort of distinction there. We took a plea deal. Story 21. Deposing a driver who caused a crash while on the job, he denied any substance use. I presented his positive meth test from his employer. His response, I never would have taken the test if I knew I'd test positive. The admission helped settle the case quickly in our favor. Story 22. In an international tax case involving transfer pricing, we discovered an email chain during discovery titled Transfer Pricing that started with, make sure to delete this email as it would be a terrible trail for the Internal Revenue Service, IRS, to follow. They had produced 10 copies, including a printed version in files. It torpedoed their defense entirely. Story 23. Not an attorney, but one client of ours baffles me to this day. He had multiple cases, including aggravated battery and substance possession. At the insistence of dude's family, we moved heaven and earth getting him a bond so that he could get out of jail and live with said family until the case was over. The whole process took weeks. Less than a day after getting out, he was caught stealing $16 worth of batteries from Target. Bond revoked. To be fair, the line between stupidity and compulsion is blurred with this one. Edit. For anyone who's curious, we immediately ordered a psychological evaluation for him. He was found competent, but it also confirmed what he had: mental health issues. The aggravated battery charge ended up being dropped, and he took a plea for time served. Story 24. Not a lawyer. Heard this story from a guy the first used to work with. His brother-in-law got injured at work and was suing for a hefty sum. Case was pretty much open and shut. All the evidence was in the brother-in-law's favor, until the brother-in-law started talking. They asked him to tell them about the day of the accident. Brother-in-law started out fine until he gets to the broth where he approached the piece of equipment that injured him. He tell everyone that there was a note on it stating that it was out of order. Brother-in-law then says that he discarded the note and started up the piece of malfunctioning equipment as he had a job to get done. That easy win was discarded faster than that out of order sign. Story 25. I had an instructor who was a prosecutor. He called a witness who had seen the whole thing and had an interest in seeing the defendant punished. Slam dunk case. She thought she was on TV. She overacted every word. Completely embellished the retelling of the events. Didn't lie, but she was the center of her version of events. He said you could see the faces of the jury members sour minute on minute. He lost the case. Story 26. I represented a girl in an aggravated assault case. Got her a really good deal where the lead charge was dropped, and she'd plead guilty to lesser charges and do 6 months on house arrest with electronic monitoring. And the ankle monitor also had to have an alcohol sensor. 1 month into her sentence, I get a call from her landlord saying she was arrested for a probation violation. Her ankle monitor detected her away from her house and that she had alcohol in her system 2 separate times, and it alerted her probation officer, P.O. I talked to her at the jail and asked her what happened. She acted like she had no idea why she was there. Her mom had just gotten out of the hospital from surgery and needed someone to watch her, so she emailed her P.O. and asked if she could go to her mom's, and then just went. Few hours later, the P.O. responded and said she couldn't go, so she went home. Also, she had wine with dinner on 2 separate occasions, so it's not like she went out drinking or anything. None of it was any big deal. I was stunned by how nonchalant she was about it. I read her the riot act. There is one rule when you're on house arrest. Don't leave your house. You left your house. There is one rule when you're on an alcohol monitor. Don't drink alcohol. You drank alcohol twice. Her P.O. was recommending she be taken off house arrest and serve 6 months in jail. I told her the judge would probably accept that recommendation, and there wasn't much I could do about it because her violations were major. We go to court for her resentencing hearing, and I beg the judge to give her something less. I highlight all my clients' positive qualities as reasons to grant leniency, along with the fact that she admitted her violations and was very forthcoming with her PO about it. The PO then piped up. When I asked her about the alcohol violations, she said she didn't know wine was alcohol. The judge was considering giving her a minimal sentence until he heard that. Completely blew apart my argument. She was open and honest. Story 27. I watched a public defender PD stomp out of the courtroom after his client was dumb enough to insist on testifying in his own defense. I'm sure he thought what the defendant had done was dumb. I didn't agree. I may be the only one. Maybe not too. Here's the story, written up on Reddit 2 years ago. I was a rural prosecutor. I had a DUI trial. Seemed cut and dried. Nothing wrong with the blood alcohol content BAC test. The people's evidence was sufficient in every way. The defendant was represented by the public defender. When I finished my half of the trial, the PD stood up and said they had only one witness, the defendant. He got sworn in, and the PD said, "Why don't you tell the jury your side of the story?" Then sat down. The jury didn't know what that meant, but the judge and I did. The defendant was insisting on testifying in spite of his lawyer's advice. The PD wasn't going to assist him in hanging himself. All the guy had to say was, "I wasn't drunk when the cop stopped me. I can drink a lot and not get drunk." That was it. Time to cross-examine. I was kind of taken aback. Our medical expert witnesses had already testified that there was no way a person with a BAC over 0.08 could safely operate a motor vehicle. I thought about just skipping cross. Nah. The jury would be curious. So I abandoned my cross-ex technique and turned into Mr. Nice Guy. I queried him on where he had been earlier that night. Moab. Okay, any drinking there? Oh, hell yes. Beer and shooters. Or something like that. Then he and his buddies had piled into the car and headed for Naturita, Colorado, maybe a 2-hour drive. Any drinking in the car? I asked. Oh yeah, plenty. He was driving, so he held back maybe only 3 or 4 beers. Any shots accompany that beer? Yeah, maybe 4. I decided that there was no reason not to let him explain himself. After all of that. How is it that you weren't drunk? The defendant explained to the jury that he had heard all the expert testimony, but even with a... Story 28. Client was part of a group involved in serious crimes against children. One of the others caused the death of the boy while several were involved with physically harming him. Our guy's defense was that he was just a voyeur, so although he was there, he was not involved in the actual incident. He was on bail the whole time, including the trial, up to when he decided to change his story and say instead that he hadn't been there. His sister gave evidence that he'd come home that night covered in blood. He got a long, long time. Story 29. Paralegal. Once had a convicted criminal explain to me how their charge for causing a death should be overturned because the victim didn't die at the scene of the crime. The victim died at the hospital, therefore the defendant couldn't be charged with anything more than attempted harm. Story 30. Not an attorney, but I was in a courtroom watching injunctions play out. One case, the woman was there, but the man was in prison, so he was calling in. After deciding on an agreement, the guy asked if he could make a statement. At the end of his statement, he said, "And tell the woman to get lost." He got an additional 6 months of prison. The guy asked to make another statement after getting a tongue lashing from the judge, and he did it again, telling her to get lost, and got another 6 months. Story 31. Around 1990, there was a guy on trial for armed robbery. He pled not guilty. A witness on the stand identified the defendant. The defendant jumped to his feet and roared, "I should have shot you when I had the chance." Pause. Thinks, adds, "If I had been the one who robbed you." Story 32. Friend of mine used to be a latent print analyst. Going to get prints of a suspect arrested for breaking into a home to rob it. While she's getting the ink and paper set up, suspect shouts, "What do you need the prints for?" She looked right at me when I kicked in the door. Story 33. Not my client but defendant posted a Facebook status along the lines of that he had, quote, taken care of business and the world is a better place because of it. He was charged with battery after putting someone in the hospital that had attacked his 14-year-old daughter. The person didn't have a clear memory of the incident, and other testimony later revealed the person beat up had an alibi for the attack in question. Most likely the girl had made up the story to avoid trouble from being out drinking underage, though we never got the full story. Anyways, the dad was sentenced to 4 years in federal prison. Story 34, Pro Bono Violence Against Women Act, VIA case. Should have been a straightforward petition. Ran a Freedom of Information Act, OIF search on the client before the final submission, just in case. Turns out she had been deported from Guam, and then while her immigration ban was still in place, she entered the mainland United States without status, equals permanently ineligible for adjustment. When I asked why she had not disclosed this during intake, her response was, "Oh, I thought Guam was its own country and not part of the U.S., so it wouldn't matter." Story 35. The mother's new boyfriend yelled at the judge because the father's lawyer dug up his criminal past. The mother had just testified that the new boyfriend was a wonderful person, and she trusted him completely. And also that he had just spent many nights with her, and the child, and that he babysat for her when she worked. She didn't get custody. Story 36. My all-time favorite is a client I had who was charged with driving under the influence, DUI, who wanted to challenge the charges on the grounds he didn't think he was drunk, and the tests was administered improperly, who appeared at his court hearings rip-roaring drunk, twice, and then, both times, he got into his car and tried to drive away. And both times, the police promptly stopped him, administered a breathalyzer, and charged him with DUI and related offenses. We didn't win that case. Story 37. Had a client show up to a child custody hearing under the influence of substances. When she arrived, she began screaming at the judge and demanding that her no-good substance-using father be substance tested. I took her in the hallway and told her that if the judge ordered a substance test for the dad, he would have to order one for her. End of argument. Story 38. Not my client and not my case, but a colleague was defending a driver in a wrongful death case. The first question at his deposition was, "Please state your name for the record." The driver stood up and started screaming at the plaintiff's attorney and threatened to harm him. That went well. Story 39. Story from a friend of mine. He was defending a guy in court, don't remember what he was charged with. The main witness for prosecution was on the stand, and was asked if she could identify the defendant. She was scanning the courtroom and seemed confused. My friend was already silently celebrating because if she couldn't identify him, he could probably get all charges dropped. As he was mentally adding this case to the win file, he happened to glance over at his client, who had just helpfully raised his hand to make it easier for her to identify him. Even the judge face-palmed on that one. Story 40. I had a brilliant gentleman on probation for substance trafficking and was not permitted to own/use a cell phone. He went in for a substance test with his probation officer, and his cell rang in his pocket. The probation officer, P.O., went to take the phone from his pocket and also pulled out a large baggie of an illegal substance. That he brought to his substance test. Story 41. Law student here, but I had a professor who was a former public defender share this gem. Her client was on probation after being released from prison and was riding his motorcycle on the highway when he saw a cop pull over another driver. He decides this was his cue to pull over as well, approach the officer, and disclose that he was currently in possession of a knife and an illegal substance, both of which would obviously violate his parole. When she asked him why the hell he would do that, he said they were going to find it eventually. Story 42. Didn't happen to me, but happened to an attorney I know. Client shows up for prelim hearing on domestic violence petition. Is wearing a ratty t-shirt, but his attorney doesn't pay attention to it. Attorney starts arguing and sees the judge turning bright red, fuming with anger. Judge asks the attorney if he spoke with his client about courtroom attire. Attorney looks down. Client is wearing a t-shirt with a very crude and misogynistic slogan on it. Story 43. Wore a shirt that said natural-born killer on it to a hearing for an assault charge. I had him turn it inside out. He went down anyway, but at least it was for, actually assaulting someone, rather than the shirt. Story 44. I work as a legal aid lawyer in a Canadian province. I have had many dumb clients who did many dumb things, wore a smoke substances every day t-shirt while attending their substance trafficking/producing trial, attempted to smuggle cigarettes to their inmate partner via their baby's diaper, intentionally soiled their pants on the way to court to delay their matter, denied driving under the influence. Upon search by police, a full highball glass of rum and coke was located in their jacket pocket. Committed a sexual assault. Sent the victim text messages from his phone the next day recalling the incident. Story 45. Not my client, but I was on the prosecutor's side when a defendant failed to appear for court. His attorney can't reach him, nobody know where he is, so we all sit there for about half an hour, until the judge gets sick of it and moves on with the docket. We found out later that day that the defendant decided to rob a 7-Eleven the night before, and was sitting in jail 2 counties over when he should have been in court.